powers of Puerto Rico in our legal system. So and you might ask, you can ask me this question later during the Q&A because I don't want to waste any time on this, but you'll go, like, why would a former U.S. attorney, somebody who was like one of the original warriors and the foot soldiers in the war on drugs, how would that person get from there to here? Okay, so that's a whole other story. I'm happy to answer that question later, but I want to get right to the subject matter because it's really a really fascinating subject. So about the time that Brock Pierce and the other crypto people got here, I'm thinking circa 2017, the Puerto Rican government came to me, and they were all excited about these crypto people that were moving here. And so they got this notion that they wanted to develop a crypto banking industry. And so they came to me and they said, look, we want you to help us convince our director of banking to allow this, So I'm scratching my head because, I was not an expert on crypto or blockchain or any of that stuff. And I'm thinking to myself, well, now this is the executive branch of the Puerto Rico government. And they're coming to me, I have no role in this government. And they're trying to figure out how to get another member of the executive branch of the government to go along with this. And this was coming from DDEC, the Department of Economic Development, which is higher on the scale inside the government than the banking division was. So I'm thinking, well, why don't you, like you got the governor's backing, just direct the guy, right? I mean, what do you need me for, So, we're having a number of discussions about this subject, and during this time period, they changed their mind. They decided they didn't want to go forward with this. But during one of the early conversations, I mentioned to them, I said, well, you're gonna meet some tough, regulatory resistance from the federal government, but you have the status. Puerto Rico has the status of being a federal agency. So, like, they were fascinated with this, and they wanted to know more about this. And then they're going, well, the secretary would really like you to write a memo on this. I said, I don't really have any interest in writing memos for you guys. This is something you guys should know. The case is obvious. The Supreme Court said this. Why are you asking me about this? And the thing was that part of my job when I was in the Virgin Islands was, I had to deal with a lot of these issues. In other words, the relationship between a territorial government and the federal government. And I will tell you that when I moved there in 1987, so I spent most of my life in the Virgin Islands, you had to throw out everything that you'd learned in law school because the relationship and the laws and the Constitution and the way it's applied in the territories is absolutely foreign to everything that you learn in law school. So that's what we're going to talk about tonight. And I'm going to give you a little primer on Puerto Rican history that is absolutely fascinating. And it led me to believe that, and this is something that I presented to the Puerto Rican government several years ago, that I had a way for them to solve the bond crisis, okay? And the reason is that if Puerto Rico would have passed an export statute, a statute that would have allowed growers in Puerto Rico to export to nations that had legalized marijuana or had medical programs. So it was a big market. Puerto Rico had 100,000 acres of farmland not being used at all, just sitting around, not on the tax rolls. I said if you took 50,000 of the 100,000 acres, and if you leased it to marijuana growers, and if you put a 10% excise tax on the import, in addition to whatever other taxes that you had, but just on that one little piece, you would produce $5 billion a year. You could immediately make those bonds performing loans. You could change your credit rating, and within about 15 years, you would eradicate the debt. So like they're all excited about this, but the problem was that, and this is the problem that this effort here, as it starts, is going to run into, which is that in my view, these Puerto Rican politicians are like totally gutless on these issues, and they won't take any risk, So keep that in the back of your mind, because as I tell you these things, you're going to get very excited about this. And I'm telling you where the resistance is going to come, okay? So here's how it goes, okay? So I thought I knew a lot about this stuff because I'd been dealing with this for 20, 30 years. And, I was pretty, I probably was one of the leading experts on the relationship between the Virgin Islands and the federal government. And I figured that Puerto Rico was going to be the same, like that the territorial laws, even though they're slightly different, that they would all fit within the same construct. And what the construct is this is how it goes. So Article 4 of the U.S. Constitution gives Congress what's called plenary authority over the territories, which means they have absolute power. They can make whatever laws that they want. The territories can't say shit. Okay, I mean they're obligated to follow that. And so the territories have zero sovereignty in this. But what happened here in a period of Puerto Rico history, and this period of time is between the late 1940s and 1953. This is the operative time that changed everything from a legal perspective. So those of you that are familiar with those years in Puerto Rico history, there was a bit of a revolution going on. There was a violent conflict that was quickly put down, by the federal government, and this was during times where the federal government was really, really misbehaving in Puerto Rico and had been for about 20 years. They had the carpetas, and they were, the FBI was following around and writing reports on all these Puerto Ricans, and you can read them now because you go up on the internet and they're there. And I've done that, and it's pretty disgusting. It'll make your stomach sick when you see what the federal government was involved in here. They had a forced sterilization program of young women. All kinds of other really, really bad stuff was going on. At the same time, post-World War II, so put this in context now, we were one of the big supporters of the development of the United Nations. Now, everybody knows that today the U.S. really doesn't give a rip about what the United Nations does. But in those days, when we were at the very beginning of this, and when we were a big promoter of the United Nations, we cared about what the United Nations thought about, and we cared about what they did. So one of the things that came out of World War II, in the United Nations, and one of their fundamental rules was, you colonial powers have to give the right of self-determination to your colonies. And what was Puerto Rico? Under the view of the United Nations, it was a U.S. colony. So every year, the U.S. had to write this very comprehensive report to the United Nations, and it had to answer a bunch of questions. And one of the things that was always going on there is, are you giving Puerto Ricans the right to self-determination? Because that was part of this process and part of this rule. And every time that the United States issued a rule, it was met with a lot of skepticism by the African countries and the Latin American countries. So the U.S. was taking some shit on this every year. So what they decided circa 1950 was, we need to get off that list. We can't have Puerto Rico as a colony. What are we going to do about this? Okay. So now this period will focus on between 1950 and 1953. So the first thing that came up, and unless you're an international lawyer, this would be meaningless to you. So nobody is really focused on this. The first law that came out in 1950 was a declaration by the United States Congress that the relationship between Puerto Rico and the federal government was one of compact, C-O-M-P-A-C-T, So, what does that mean? It's sort of a meaningless term unless you're in that space. But a compact is an agreement between sovereign nations, okay? So this is really pretty profound, because here all the law and all the Supreme Court law governing the U.S. territories was always, look, you territories are nothing, we control everything, you have no sovereignty, okay? Now all of a sudden, there's this pronouncement that any agreements between Puerto Rico and the federal government are one of two entities that have sovereign entering essentially a treaty, or it doesn't have to be a treaty, it could be less than a treaty, but an agreement, okay? So, nobody really notices the change. This is what the U.S. is doing because they want to make their pitch to the UN to get off this list, okay? So the next thing they do is they say, well, okay, so we got to give Puerto Rico a constitution, Now, I don't know how much anybody knows about this, and I don't mean to be insulting, any Puerto Rican hero in all this, but I will tell you that, any of you that have read about the history of Luis Maria Munoz, you're going to find some interesting things. So he was like an opium addict, and the FBI controlled this guy. They really used that, and they were able to get the governor of Puerto Rico to do what they wanted because they had the goods on him, and they used it pretty viciously too. So so they trot him out and they say, go get us a constitution. Puerto Rico needs a constitution. So it wasn't like there was this great upswelling of local patriotic support for the Constitution. It didn't get generated from the bottom up. This was a directive from the federal government. So Puerto Rico comes up with a constitution. Now, part of the problem at this point, and I don't want to get into too much of a digression on other parts of Puerto Rican history, but there was a guy named Rex Tugworth who was part of the New Deal part of the brainchildren that came up with that. He was part of Roosevelt's administration, but he was a socialist, and he was starting to cause some problems in Washington. So Roosevelt had to get rid of him. So what do? He sent him down here to be the chief administrator and then later the governor. So there's a lot of wacky laws that we have in Puerto Rico. So here's something you probably don't know. If you don't do anything with one of your bank accounts, let's say you have a bank account that's dormant for 5 years anywhere in the world, there's a Puerto Rican law that says Puerto Rico can forfeit that. Puerto Rico can take your money, okay? You get a well, you get a license for a well, you get a permit for a well here, and you think, well, the water is underneath, my house, it's my water, right? No, it's not your water. And when you put the well in, you got to pay something like, I don't remember what it is, but it's a few cents a gallon to the Puerto Rican government because they own the water. So there is, because of Tugworth's position here, there's a lot of socialist laws in Puerto Rico, okay? So what comes out of the Constitution is consistent with that. There were some social welfare provisions in that Constitution that Congress said, no, we're not having any of that. So they whip up their puppet, so to speak, and they tell the governor, you need to fix this, you need to get rid of these provisions, and then we'll approve it. And that's what happens, So they get rid of those social welfare things, and now, 1952, Puerto Rico has a constitution. So one more step in what the government wanted to present to the United Nations to get off this list. But they weren't done. And in 1953, and this is the key one, this is the one that we're going to focus on in terms of what Puerto Rico could do to, say, license psilocybin as a medicine, or MDA, or really any other substance for that matter. So what happens in 1953 is that they reduced the entire, what was known as the Puerto Rico-U.S. Federal Relations Act to a single sentence. And that sentence says, okay, and I'm going to get you to focus on 3 words, okay? What that sentence says is all federal laws, statutory laws now in effect, shall be in full force and effect in Puerto Rico, except for those that are locally inapplicable. Now, this is a fascinating thing to any, constitutional scholar. And to those of you that have studied American history, you may recall that in 1830, South Carolina passed a law known as the Nullification Act, and they were going to nullify different federal laws, And the Supreme Court said, oh, no, you're not. We have a federal supremacy law. That law makes the federal law, sacrosanct. You can't screw around with that. So forget those statutes that you passed, South Carolina, they're no good. And that has been the law in this country, for literally the last 200 years. But there's one place, and only one place under the U.S. flag, where that doesn't apply. And it doesn't apply because of the law that I just told you. Because Puerto Rico can say that law, that federal law, is not locally applicable here. So when you think about the FDA, you really can, thumb your nose at the FDA if you want to do this, if you had the backing of the Puerto Rican government. So let's now move to a different era in American history, and let's go to, and let's talk about cannabis for a second, because it's very relevant what happened here with cannabis, because you can use this as a model to get psilocybin and MDMA made legal under Puerto Rican law, as medicine. So, but first I need to tell you that what wasn't said in the 1953 statute, and by the way, these are the weaknesses in the position that I take here, is that okay, so what does it mean, when a law is not, when a federal law is not locally applicable? And, there's nothing in the legislation about that. So that was an open question. And then the second question, which is equally important in this, is who determines what law is not locally applicable? So those things, there's no statutes on that. There's nothing on that. These were open questions. So the position that I take, and I'll tell you it's not, 100% rock solid. It's just a position, okay, has to do with the first time this came up, okay? And the first time it came up was in 1956 in a drug law known as the Harrison Act. And one of the things that you look at when federal laws are written, because not all the federal laws apply to the territories. And a lot of times it's by accident. It's like, the guys that are drafting the statutes will say, made applicable to all the states, and they won't think about the things that are not states that the U.S. government either owns or controls. So, so there were, we went through this a lot, in the criminal law, when I was a prosecutor, because you had to really study to see whether or not this law applied to the territories or not. The particular one that you might have wanted to prosecute somebody under. But what happened in 1956 was that the Harrison Act was the broadest jurisdictional grab that the federal government could do, because they used the word possessions. In other words, this law applied to all U.S. possessions. And possession under this concept of jurisdictional law has the broadest application, because what does it mean? It means all the states. It means all the territories. It means every rock and atoll and outpost that the U.S. government might own. Okay, so it's the broadest application. So when we look at that law, we can't say, oh, it's an anomaly because maybe there was an argument that it shouldn't have applied to the territories. No, it applied to everything the United States government owned. And the very last section of this statute, there's a carve-out, and it says that despite this broad application of this drug law, this law does not apply in Puerto Rico unless the Puerto Rican legislature adopts it, okay? So where I go from this, and like I say, this is not a lead pipe cinch 100% position, but based on that statute, my position is that the federal government answered the question. It at least answered one of those two questions, okay? It didn't answer what should be locally inapplicable, what should be locally applicable. It did not answer that question. But it did answer the question of who decides. And what Congress said is, okay, we have this 1953 law, therefore, we need to ask Puerto Rico whether they want this law or not. And what happened after that was the legislature said, oh yeah, we want that law, so that became law in Puerto Rico. Now that whole concept and that whole theories of taking the step-by-step in terms of thinking of these issues and whether or not these laws apply have been honored in the breach since 1956. And, Congress is passing laws and they apply in Puerto Rico theoretically. And there's even a few cases where some defense attorneys tried to object to that. The First Circuit shut them down. But I don't know that those issues were raised the way I'm telling you about tonight, okay? Because I think this is very powerful to show what Congress actually did in this situation right after that statute was passed. Like nobody's thinking about it now, right? Because it's 70 years later, okay? So when I was explaining to the Puerto Rican government what they could do to solve this bond crisis if they would pass this export statute, I went through all of this with them, and they're really fascinated that they, could have that kind of power. And even in the Sanchez Valle case, which stood for the proposition that if you had a prosecution by either the local government or the federal government, that they're seen as one government, and so there's no, you couldn't raise that sovereignty issue in that case. What the Supreme Court said is, yeah, That's the rule because we have that, those series of precedents. It's a historical rule, okay? But I think it was Kagan that was the author of that opinion. She went to great lengths to say, but Puerto Rico's status is unique under the federal system, and that the Puerto Rican government has an amazing amount of power under the law. Now, she didn't go into all the details like I've gone into with you today, but it's, it's there. It's ready to be grabbed. It's ready to be used, okay? So it's going to take some political will to make that happen. But I'll tell you what my basis for telling the local government was that they had the power to issue an export statute, and here's why. And so let's go through that analysis we went through, and let's talk about the facts. So, and Rick's going to love this because he studied all the abuses of Richard Nixon and what he did to us with the Controlled Substance Act, and I'm a student of this. I know all this stuff, and I can tell you that, Tricky Dick, he hated, marijuana and heroin. And he hated these two drugs because there were two groups of people he hated, Jews and blacks. And why did he hate them? Because he saw them as the greatest forces against the Vietnam War. And he had no interest in ending that war, okay? And, the things that he and Kissinger did during the Nixon years, I mean, it's terrible. It's disgusting, all the millions of people that they killed over there. But so he was determined to keep that going, so he had to crush the anti-war movement. And the way he crushed the anti-war movement was making heroin and marijuana Schedule I drugs, okay? The most serious drugs, and what that means is no medical use. So, so it was temporary, so he had to get a commission to support this. So he appoints this former governor of Pennsylvania named Raymond Schaefer, who was a law and order governor. And he says, Raymond, if you do this for me, if you serve as the head of this commission, which was known as the Schaefer Commission, I will give you a lifetime appointment as a federal district court judge. So Schaefer says, yes, I'll do it. They put this panel together. They study this for a year. And guess what the panel says? The panel says marijuana is not dangerous, Nixon's furious, so what he does is he ignores that, and he keeps going on with his evil ways. And what he did was, and now, as evil as the guy was, he was a very smart lawyer. Now, when Congress passes a law, okay, they have to have some constitutional foundation to it. In other words, there's got to be some provision in the Constitution that allows the authorization of that law. And so to support the Controlled Substance Act of 1970, what they did was they relied on the Commerce Clause. So in other words, this involved business, basically. So Nixon knew that this was a stretch. Now, ultimately, the Supreme Court did back him up, and they said the Commerce Clause was okay. But in 1970, he did not know that, okay? And there were a lot of legal scholars that are going, hey, you're on shaky ground here. This may not work, as a basis for this law. So like I say, Nixon was a brilliant lawyer, so what did he do? He decided to get all the states to adopt the same law. Not just the states, but the territories too. And then he figured if the Supreme Court struck down the Federal Controlled Substances Act, it really didn't make any difference because it would be the law of the land because every state would have adopted it. And he was quite successful in doing that. So here's the very interesting thing that happened in Puerto Rico. So when Puerto Rico adopts the law, it's not the DEA, it's not the FDA, it's no part of the federal government that gets to say shit about who schedules the drugs and what schedule they're going to be. It is the Departamento de Salud, the Puerto Rican Department of Health, okay? So now let's go back, I'm being a bit of a law professor here, and go back to what I had just told you, okay? What's locally applicable? Puerto Rico said in 1971 that what is locally applicable in Puerto Rico is that we're going to determine the schedule of drugs. And what is locally inapplicable is the federal government is not going to determine the schedule of those drugs. Now, they said that in 1971, and for 44 years it made no difference, right? Because Puerto Rico didn't try to reschedule any drugs. It didn't do anything like that. But when Alejandro Padilla was governor, he directed the Department of Health here to reschedule marijuana from Schedule I to Schedule II so that they could develop a medical marijuana law and a medical marijuana program here. And that is exactly what happened. So we closed the loop on this discussion then, right? Puerto Rico decided what was locally applicable and what was locally inapplicable in 1971 when they adopted the territorial version of the Controlled Substance Act. And 44 years later, they went ahead and said, okay, we have the right to do this. We're going to reschedule this. And, the federal government didn't say boo. Now, of course, one could say, well, the federal government didn't say boo on all these other programs, and has taken a bit of a hands-off, attitude towards local cannabis programs. So what I'm saying is that there is a legal basis if one gets the Department of Health to go along with this. The government and the advocates for this kind of medicine can say, and guess what, federal government? You have no business in this area, okay? We have spoken, okay? Now, I will tell you as a former federal official that the attitudes of Puerto Rico and the Virgin Islands towards the federal government are very, very different, okay? Here, the Puerto Rican government gets down on its hands and knees and will do whatever the federal government wants, okay? And a lot of that is this sort of this blue party concept, and I'm really apolitical, so don't draw anything from this. I'm just observing this. That in an effort to get statehood, the blue party thinks, well, we'll just give the federal government whatever they want, and if we have a law like 936, for example, and the federal government doesn't like it, well, we'll get rid of it, because we want statehood. And I will tell you from being on the other side of these issues, that is not how you win with the federal government. You take a position, you challenge them. You don't necessarily stick them in the eye, but you stand up for your rights, which the Virgin Islands government did all the time when I was there. And I watched, the inside of the federal government in Washington react to this stuff, and a lot of times they disagreed with the Virgin Islands government, but they were very respectful because they did not want to be, didn't want to be perceived as this colonial power, And when it came to putting a control group like we have here, in charge of the Virgin Islands, because the Virgin Islands had similar, economic problems that Puerto Rico has. No, the U.S. Department of Interior, which has authority over all the territories except Puerto Rico, because Puerto Rico has a direct line to the White House, which occurred in this 1950 to 53 time period. But the Interior Department stood up against Congress and said, no, we are not going to support this financial control law as it relates to the Virgin Islands, because that would be colonial, Now, I don't know, I don't think we heard much of that when the federal government was doing this to Puerto Rico a few years ago. I mean, I'm sure the issue was raised, but there wasn't really much resistance, from the Puerto Rico government, and the government didn't have the access to the Interior Department because the Interior Department didn't really have any jurisdiction over Puerto Rico like it does the other territories. So there is a path forward if one wants to take it, okay? And what I had advised the Puerto Rico government to do is go ahead and pass an export statute, put a moratorium on it for 1 year. And during that 1 year, you start negotiating with the federal government. And you take the position that you have the authority to do this, you lay out the law the way I've laid it out for you, and you work on finding a way forward and a compromise. And I would do that with the FDA too, because if the FDA ends up becoming an advocate, which is hard to imagine, but I mean, I think the approach would be take this as one component of medical tourism, okay? I would add, I was telling David, I would add regenerative medicine to this as well. Just like you were saying, Tanya, about there's 27%, more mental health issues here. Well, our aging population is 21% of those over 65. It's 17 in the States. We are at a higher risk with older people. I'd be saying, let us study, let us be a laboratory for these psychedelics. I'd want to be a laboratory for stem cells, for umbilical stem cells. And I would want to approach this on a much larger way of us being a laboratory, because then we are aiding and assisting, in the development of information, and we might not then be seen as, creating some friction with the federal government. So there is a way to proceed on this, and I'll do a little work on this, and I'll lay this out for you, in a subsequent memorandum. But I think you're going to get, I think David told me, a very short memo that I wrote for the local government on this issue. But there's much longer ones, okay? And there's much more in-depth ones. And there's ones that go into, there's lectures that I've given on this whole, like Nixon federal, drug control law. But I'm going to stop now because I don't want to extend the time so Rick can have the whole time here, but I'll be happy to answer any questions that you might have about this when Rick's done.
Well, could I ask you a question
Sure.
now? Which is, the Oregon has made psilocybin medicine.
Right.
Colorado has made natural plant medicine.
Right.
It's going to be on the ballot in Massachusetts in November for natural plants. And if Puerto Rico were to do something, is the distinction that you're saying is that the federal government, if they decided to shut down Oregon and Colorado and potentially Massachusetts, they could do so, but they couldn't shut down?
Yes, that's exactly what I'm saying, because the supremacy clause would say in all these other places, hey, look, if the federal law is X and you try to do Y, tough luck, federal law rules. But here the federal government has said, no, it doesn't, okay? Now, we could get into a lot of discussions about, what does locally inapplicable mean? Is it a home rule issue? Does it apply to the situation? Those are open questions. But I would also say, but look at what they did in 1956, and this was Congress's view of what that law that they passed in 1953 meant. So the postscript to all this is that the federal government got its dog and pony show together in 1953, and it went to the UN to get off this list. And during that time, and during those presentations, they introduced a letter from the president or a representation from the president. I don't know if it was actually written or not. And it said that at any time that Puerto Rico wanted independence, it would be immediately granted by the federal government, okay? Because the point of that was they wanted to show that Puerto Rico had more sovereignty than any state in the Union. And they made that point very clear. So the last point on this, from a very, very technical legal argument, and I hope you won't mind me getting that deep into the weeds on this, is that there is a doctrine under federal law that is called judicial estoppel. There's also administrative estoppel. And what it means is that if you tell, the administrative estoppel doctrine goes like this. If you tell a taxpayer that if you file your tax return by X date, that you will have the right to challenge this, for example. And the taxpayer listens to the federal government and follows that. The federal government can't then say, oh, no, we were wrong about that, and you don't have that right, okay? Because think about that. That's fundamental fairness, right? If the government tells a citizen that their course of intended action is correct and legal, you can't then come back and punish that person, for the advice that you gave them. And judicial estoppel means that if the federal government takes a position in a court case, the federal government can't come back and take a different position, even in different litigation. Once they say that's what's called judicial estoppel. You are stopped from doing this thing that you now want to do. So now this is a gray area. This is not something conclusive. But I would say, okay, but when the executive branch and Congress, because it was both branches that went to do this dog and pony show at the UN, okay, if those two branches of government go and take the position that is the official position of the United States government, that Puerto Rico has more sovereignty than a state, okay, then I would say that clever lawyers ought to make an estoppel argument against that if they now change their tune, okay? And there are parts of the federal government that would be very open to these arguments, okay, and would be very nervous about fighting against them. But what it's going to take here to make any of that happen is something that we don't have a lot of down here. and that's political courage. Okay, so that's my final point on the subject. Thank you for listening so intensely. I hope you enjoyed it.